Good morning, Canada. Alex Monahan here, Foundations Party, ineligible. Today's date is April 14th, 2017, and we are going to continue reading the the Immigration Refugee Protection Act. And we're going to pick off where we left off at the bottom of paragraph 58 at 1.1. So, and this will be the first half of this part today, and like usual, without further ado, let us begin. Continued determination, designated foreign national. Subparagraph 1.1, despite subsection 1, on the conclusion of a review under subsections 57.1, the Immigration Division shall order the continued detention of the designated foreign national if it is satisfied that any of the grounds described in paragraphs 1a to c and e exist, and it may not consider any other factors. Detention, Immigration Division. Subparagraph 2. The Immigration Division may order the detention of a permanent resident or a foreign national if it is satisfied that the permanent resident or the foreign national is the subject of an examination or an admissibility hearing, or is subject to a removal order, and that the permanent resident or the foreign national is a danger to the public or is unlikely to appear for examination. And an admissibility hearing or removal of Canada. Conditions. Subparagraph 3. If the Immigration Division orders the release of a permanent resident or a foreign national, it may impose any conditions that it considers necessary, including the payment of a deposit or the posting of a gratuity for compliance with the conditions. Conditions. Designated foreign national. Subparagraph 4. If the Immigration Division orders the release of a designated foreign national who is 16 years of age or older on the day of the arrival, that is the subject of the designation in question, it shall also impose any conditions that is prescribed. Next page. Release. On request. Paragraph 58.1, subsection 1. The minister may, on request of a designated foreign national who was 16 years of age or older on the day of the arrival, that is the subject of the designation in question, order their release from detention if, in the minister's opinion, exceptional circumstances exist that warrant the release. Release. Minister's own initiative. Subparagraph 2. The minister may, on the minister's own initiative, order the release of a designated foreign national who was 16 years of age on or older on the day of the arrival, that is the subject of the designation in question, if, in the minister's opinion, the release of the designation no longer exists. Conditions, subparagraph 3. If the minister orders the release of a designated foreign national, the minister may impose any conditions, including the payment of a deposit or the posting of a gratuity for compliance with the conditions that he or she considers necessary. Incarcerated foreign nationals, paragraph 59. If a warrant of arrest and detention under this act is issued with respects to a permanent resident or a foreign national who is detained under another act or parliament in an institution, the person is charged of the institution shall deliver the inmate to an officer at the end of inmate's period of detention in the instruction. That's interesting. Minor children, paragraph 60. For the purpose of this division, it is affirmed as a principle that a minor child shall be detained only as a measure of least risk or last resort, taken into account the other applicable grounds and criteria, including the best interests of the child. Regulations, paragraph 61. The regulations may provide for the application of this division and may include provisions respecting a grounds for the criteria with respect to the release of a person from detention. Subparagraph A1. The type of conditions that an officer, the Immigration Division, or the minister may impose with respects to the release of a person from detention. Subparagraph A2. The type of conditions that the Immigration Division must impose with respects to release of a designated foreign national who was 16 years of age or older on the day of the arrival of that is the subject of the designation in question. B. Factors to be considered by an officer or the Immigration Division. And C. Special consideration that may apply in relations to the detention of a minor child. Division 7. Right of appeal. Competent jurisdiction. Paragraph 62. The Immigration Appeal Division is the competent division of the border with respects to appeals under this division. Right to appeal. Visa refusal of family class. Paragraph 63, subparagraph 1. A person who has filed in the proscribed manner an application to sponsor a foreign national as a member of the family class may appeal to the Immigration Appeal Division against a decision not to issue the foreign national a permanent residence visa. Rights to appeal. Visa and removal order. A foreign national who has a permanent resident visa may appeal to the Immigration Appeal Division against a decision to make a removal order against them made under subsection 44(2) or made at an admissible hearing. Admissibility hearing. Right to appeal removal order. Subparagraph 3. A permanent resident or a protected person may appeal to the Immigration Appeal Division against a decision made decision to make a removal order against them made under subsection 44.2 or made at an admissibility hearing. Right of appeal. Residency obligations. Subparagraph 4. A permanent resident may appeal to the Immigration Appeal Division against a decision made outside of Canada on the residence obligation under Section 28. Right to appeal. Minister. Subparagraph 5. The minister may appeal to the Immigration Appeal Division against a decision of the Immigration Division in an admissibility hearing. No appeal for inadmissibility. Paragraph 64, subparagraph 1. No appeal may be made to the Immigration Appeal Division by a foreign national or their sponsors or by a permanent resident in a foreign national if the foreign national or permanent resident has been found to be inadmissible on grounds of security, violating human or international rights, serious criminality, or organized criminality. Serious criminality, subparagraph 2. For the purposes of subsection 1, serious criminality must be with respects to a crime that was punishable in Canada by a term of imprisonment of at least 6 months, or that is described in paragraph 36(1)(b) or (c). Misrepresentation. Subparagraph 3. No person may be made no appeal may be made under subsection 63(1) in respects of a decision that was based on a finding of inadmissibility on the grounds of misrepresentation unless the foreign national in question is the sponsor's spouse, common law partner, or child. Humanitarian and compassionate considerations. 65. In the appeal under subsection 63(1) or 2, respecting an application based on membership in the family class, an Immigration Appeal Division may not consider humanitarian and compassionate consideration unless it has determined that the foreign national is a member of the family class and that their sponsor is a sponsor within the means of the regulations. Disposition. Paragraph 66. After considering the appeal of a decision, the Immigration Appeal Division shall a. allow the appeal in accordance with Section 67, b. stay the removal order in accordance with Section 68, or c. dismiss the appeal in accordance with Section 69. Appeal allowed. Paragraph 67, subparagraph 1. To allow an appeal, the Immigration Appeal Division must be satisfied that at the time the appeal is disposed of, a. The decision appealed is wrong in law or fact or mixed law and fact, b. a principle of natural justice has not been observed, or c. other than in the case of an appeal by the minister taken into account by the best interest of a child directly affected by the decision, sufficient humanitarian and compassionate consideration warrant special relief in light of all circumstances of the case. Effect, subparagraph 2. If the Immigration Appeal Division allows the appeal, it shall set aside the original decision and substitute a determination that in its opinion has been made, including the making of a removal order, the refusal, to or refer the matter to the appropriate decision maker of reconsideration decision maker for reconsideration. And that's going to be all for this part. We're going to continue off in a few minutes here with the removal order. Thanks for watching, and stay posted.